Welcome to the series of the Indian Penal Code. In this video, we are going to see Chapter 3, titled Of Punishments. Chapter 3 reads from Section 53 to Section 75. Section 53, Punishments. The punishments to which offenders are liable under the provision of this code are: first, death; secondly, imprisonment for life; third has been omitted; fourthly, imprisonment, which is of two descriptions, namely rigorous, that is with hard labor; two, simple; fifthly, forfeiture of property; sixthly, fine. Section 53A, Construction of reference to transportation. 1. Subject to the provisions of subsection 2 and subsection 3, any reference to transportation for life in any other law for the time being in force, or in any instrument or order having effect by virtue of any such law or of any enactment, repealed, shall be construed as with reference to imprisonment for life. 2. In every case in which a sentence of transportation for a term has been passed before the commencement of the Code of Criminal Procedure, Amendment Act 1955, 26 of 1955, the offender shall be dealt with in the same manner as if sentenced to rigorous imprisonment for the same term. 3. Any reference to transportation for a term or to transportation for any shorter term by whatever name called in any other law for the time being in force shall be deemed to have been omitted. Any reference to transportation in any other law for the time being in force shall, if the expression means transportation for life, be construed as reference to imprisonment for life. B. If the expression means transportation for any shorter term, it be deemed to have been omitted. Section 54, Commutation of sentence of death. In every case in which sentence of death shall have been passed, the appropriate government may, without the consent of the offender, commute the punishment for any other punishment provided by this code. Section 55, Commutation of sentence of imprisonment for life. In every case in which sentence of imprisonment for life shall have been passed, the appropriate government may, without the consent of the offender, commute the punishment for imprisonment of either description for a term not exceeding 14 years. Section 55A, Definition of appropriate government. In sections 54 and 55, the expression appropriate government means: A. In cases where the sentence is a sentence of death or is for an offence against any law relating to a matter to which the executive power of the Union extends, the central government; and B. In cases where the sentence, whether of death or not, is for an offence against any law relating to a matter to which the executive power of the state extends, the government of state within which the offender is sentenced. Section 56. Sentence of Europeans and Americans to penal servitude. Provisions as to sentence for term exceeding 10 years but not for life, repealed by the Criminal Law Removal of Racial Discrimination Act 1949, 17 of 1949, with effect from 6/4/1949. Section 57. Fractions of terms of punishment. In calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. Section 58. Offenders sentenced to transportation, how dealt with until transported. Repealed by the Code of Criminal Procedure Amendment Act 1955, 26 of 1955, Section 117 and the schedule with effect from 1/1/1956. Section 59. Transportation instead of imprisonment. Repealed by Section 117 and the schedule with effect from 1/1/1956. Section 60. Sentence may be in certain cases of imprisonment wholly or partly rigorous or simple. In every case in which an offender is punishable with imprisonment, which may be of either description, it shall be competent to the court which sentences such offender to direct in the sentence that such imprisonment shall be wholly rigorous, or that such imprisonment shall be wholly simple, or that any part of such imprisonment shall be rigorous and the rest simple. Section 61. Sentence of a forfeiture of property, repealed by the Indian Penal Code Amendment Act 1921, 16 of 1921 and Section 4. Section 62. Forfeiture of property in respect of offenders punishable with death, transportation or imprisonment has been repealed by the Indian Penal Code Amendment Act 1921, 16 of 1921. Section 63. Amount of fine. Where no sum is expressed to which a fine may extend, the amount of fine to which the offender is liable is unlimited but shall not be excessive. Section 64. Sentence of imprisonment for non-payment of fine. In every case of an offence punishable with imprisonment as well as fine, in which the offender is sentenced to a fine, whether with or without imprisonment, and in every case of an offence punishable with imprisonment or fine or with the fine only, in which the offender is sentenced to a fine, it shall be competent to the court which sentences such offenders to direct by the sentence that in default of payment of the fine, the offender shall suffer imprisonment for a certain term, in which imprisonment shall be in excess of any other imprisonment to which he may have been sentenced, or to which he may be liable under a commutation of a sentence. Section 65. Limit to imprisonment for non-payment of fine when imprisonment and fine awardable. The term for which the court directs the offender to be imprisoned in default of payment of a fine shall not exceed 1/4 of the term of the imprisonment, which is the maximum fixed for the offence, if the offence be punishable with imprisonment as well as fine. Section 66. Description of imprisonment for non-payment of fine. The imprisonment which the court imposes in default of payment of a fine may be of any description to which the offender might have been sentenced for the offence. Section 67. Imprisonment for non-payment of fine when offence punishable with fine only. If the offence be punishable with fine only, the imprisonment which the court imposes in default of payment of the fine shall be simple, and the terms for which the court directs the offender to be imprisoned in default of the payment of fine shall not exceed the following scale, that is to say, for any term not exceeding 2 months, when the amount of fine shall not exceed 50 rupees, and for any term not exceeding 4 months, when the fine amount shall not exceed 100 rupees, and for any term not exceeding 6 months in any other case. Section 68. Section 68. Imprisonment to terminate on payment of fine. The imprisonment which is imposed in default of payment of fine shall terminate whenever the fine is either paid or levied by process of law. Section 69. Termination of imprisonment on payment of proportional part of fine. If before the expiration of the term of imprisonment fixed in default of payment, such a proportion of the fine be paid or levied that the term of imprisonment suffered in default of payment is not less than proportional to the part of the fine still unpaid, the imprisonment shall terminate. Illustration. A is sentenced to a fine of 100 rupees and to 4 months imprisonment in default of payment. Here, if 75 rupees of the fine be paid or levied before the expiration of 1 month of the imprisonment, A will be discharged as soon as the first month has expired. If 75 rupees is paid or levied at the time of the expiration of the first month or at any later time while A continues in imprisonment, A will be immediately discharged. If 50 rupees of the fine be paid or levied before the expiration of the 2 months of the imprisonment, A will be discharged as soon as 2 months are completed. If 50 rupees be paid or levied at the time of the expiration of those 2 months or at any later time while A continues in imprisonment, A will be immediately discharged. Section 70. Fine leviable within 6 years or during imprisonment. Death not to discharge property from liability. The fine or any part thereof which remains unpaid may be levied at any time within 6 years after the passing of the sentence, and if under the sentence the offender be liable to imprisonment for a longer period than 6 years, then at any time previous to the expiration of that period and the death of the offender does not discharge from the liability any property which would after his death be legally liable for his debts. Section 71. Limit of punishment of offence made up of several offences. Where anything which is an offence is made up of parts, any of which part is itself an offence, the offender shall not be punished with the punishment of more than one of such his offence, unless it be so expressly provided. Where anything is an offence falling within two or more separate definition of any law in force for the time being, by which offences are defined or punished, or where several acts of which one or more than one would by itself or themselves constitute an offence, constitute when combined a different offence, the offender shall not be punished with a more severe punishment than the court which tries him could award for any one of such sentence. Illustration A. A gives Z a 50 strokes with a stick. Here, A may have committed the offence of voluntarily causing hurt to Z by the wrongful whole beating, and also by each of the blows which make up the whole beating. If A were liable to punishment for every blow, he might be imprisoned for 50 years, one for each blow. But he is liable only to one punishment for the whole beating. B. But if while A is beating Z, Y interferes and A intentionally strikes Y here, as the blow given to Y is no part of the act whereby A voluntarily causes hurt to Z, A is liable to one punishment for voluntarily causing hurt to Z and to another for the blow given to Y. Section 72. Punishment of person guilty of one of several offences, the judgment stating that it is doubtful of which. In all cases in which judgment is given that a person is guilty of one of several offences specified in the judgment, but that it is doubtful of which of these offences he is guilty, the offender shall be punished for the offence for which the lowest punishment is provided, if the same punishment is not provided for all. Section 73. Solitary confinement. Whenever any person is convicted of an offence for which, under this code, the court has power to sentence him to rigorous imprisonment, the court may, by its sentence, order that the offender shall be kept in solitary confinement for any portion or portions of the imprisonment to which he is sentenced, not exceeding 3 months in whole, according to the following scale, that is to say, a time not exceeding 1 month, if the term of imprisonment shall not exceed 6 months. A time not exceeding 2 months, if the term of imprisonment shall exceed 6 months and shall not exceed 1 year. A time not exceeding 3 months, if the term of imprisonment shall exceed 1 year. Section 74. Limit of voluntary confinement. In executing a sentence of voluntary confinement, such confinement shall in no case exceed 14 days at a time, with intervals between the period of solitary confinement of not less duration than such periods. And when the imprisonment awarded shall exceed 3 months, the solitary confinement shall not exceed 7 days in any 1 month of the whole imprisonment awarded, with intervals between the period of solitary confinement of not less duration than such periods. Section 75. Enhanced punishment for certain offences under Chapter 12 or Chapter 17 after previous conviction. Whoever, having been convicted by a court in India of an offence punishable under Chapter 12 or Chapter 17 of this code with imprisonment of either description for a term of 3 years or upwards, shall be guilty of any offence punishable under either of those chapters with like imprisonment for the like term, shall be subject for every such subsequent offence to imprisonment for life or to imprisonment of either description for a term which may extend to 10 years.